law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been designed to help inform, educate, and inform you because the law matters. If you understand the law better, you're in a better position to protect yourself, your family, and the people who matter to you, your business included. We provide information and resources that'll help you determine whether or not you want to contact an outside lawyer. Perhaps will help you so that you can handle some issues yourself. If you do decide to select outside counsel, you'll be better prepared, and hopefully so will the outside counsel you select. Either way, you're supposed to be saving time, money, and hopefully achieve better results. The Bazar Law Firm in East Providence continues to help us by providing their insights, their experience, and their information on the various topics that we handle. And we want to thank them and, of course, welcome David Bazar.
Thank you.
Happy New Year. So today, thank you. So today we're going to discuss personal injury. What does that encompass? What do we need to know? How do you even know if you have a viable case? That category seems to capture such a wide swath of kinds of cases. We thought we'd go to David to give us the specifics. Personal injury, it's tort. What is it and what does it mean?
It does, as you say, encompass a wide range of types of situations. What they do have in common generally is that somebody was negligent, and as a result of their negligence, you were injured, and then there's a claim for your personal injury. That's why we call it a personal injury case. What are the types of cases that can result in that? Well, of course, auto accidents are a very large portion of that type of case. Then there's slip and fall cases. Someone goes to a restaurant or a supermarket or some other place and is injured as a result of the negligence of the storekeeper or the homeowner or whoever it is. So there's the slip and fall case. This time of year you get a lot of slip and fall cases outside with the weather, snow and ice, and sometimes it's just a natural accumulation of snow and ice that isn't anybody's fault, and sometimes somebody's responsible for failing to remove it. Then there is malpractice cases. Personal injury resulting from medical malpractice would fall under that. There could be cases where your liberty is restrained. I'm thinking of like cases of false imprisonment and that type of thing, which you could also say might fall under personal injury type of cases.
I understand that some of the others, product liability, somebody did something wrong in the creation of the product or how they use the product, or even boating, I understand, can be part of a car accident, a personal injury case.
Sure. So, for example, products liability cases, which we've handled in the past, the product is defective, and we could do a whole show on just products liability and all the things and the types of theories of law that you can get into in determining whether or not a product is defective. But the bottom line result is that the defective product causes an injury to a person, and they then have a personal injury case. Boating cases, just like automobile cases, if someone is negligent in the operation of a boat, and I've had and seen cases where someone has fallen into the water, and in an attempt to get them out, the operator of the boat negligently backed up over the person and caused serious injury, that type of thing. So again, any type of negligence which causes an injury to somebody else is what would fall into the category that you started the show with as personal injury.
And that's what's called tort, and there's a difference between tort and civil and, and criminal.
So tort law encompasses civil wrongs, and so civil wrong can come under a lot of different types of things. Personal injury cases, negligence, those are torts. There is the case we talked about false imprisonment. That's a civil wrong, that's a tort. Torts encompass any type of civil wrong from one person to another, as opposed to a criminal case, which involves violating a law and the state having the claim against you as the defendant.
When they talk about personal wrongs or civil wrongs, they talk about them being either economic or non-economic. What's non-economic encompass?
Well, a non-economic loss or damage that I'm thinking of, perhaps an equitable situation where you have some type of restraint against you that isn't going to be resolved by money damages, but rather an injunction or that type of thing.
Oh, I see. Okay. And when someone thinks that they have a personal injury, What is the process? I assume that of the things that we say someone can do by themselves, when it comes to something like personal injury, probably not something they want to handle on their own. How do you determine whether there's a viable case? How could you help our viewers determine whether or not it's even worth it for them to approach you or someone like you, another lawyer?
So if you are injured as a result of somebody's negligence, it's almost always worth speaking to an attorney about it. Now, generally, an attorney is not going to take a case unless the injuries are somewhat significant. But in Rhode Island, if you're in an auto accident, someone rear-ends you, and you have to go to a hospital, and you're in pain, and there's some suffering that's going on as a result of that, and perhaps you lost time from work and incurred medical bills, an attorney is going to represent you. And why would you go to an attorney rather than do it yourself? Well, first of all, if you do it yourself, the insurance company knows that you don't have the capability of bringing the case to court or some other form of mediation or dispute resolution on your own. So they are going to evaluate the claim that you have accordingly and give you less money. An attorney will always take those cases on a contingency. And a contingency fee is a percentage of whatever the total recovery is. So if there's no recovery, you don't pay the attorney anything. And the reason attorneys will take these cases on a contingency is, generally speaking, someone coming to an attorney who's been involved in a personal injury, to hire an attorney on an hourly basis is cost prohibitive. So by taking on a contingency, you only pay based on what you recover. And for the attorney, the recovery can be significant, and the contingent fee allows the playing field, so to speak, to be leveled between the defendant, really the insurance company, that would have pretty much unlimited funds in comparison to an individual who's bringing the case in the first place. And
when you talk about contingency, is it still a rule of thumb that 30% might be a good starting place, depending on what is involved with any particular case?
Auto accident type of cases, slip and falls, those types of things, attorneys usually would do it a third. Attorneys learn to divide by 3 very quickly and very well. But that's not usually the case for the more complicated liability cases of product liability or medical malpractice, where the expenses involved in those cases can be extremely significant, and the attorneys usually will front all the expenses. The return, therefore, is usually probably more like 40%, in some cases 50%, depending on whether or not the case can be resolved or it has to go to suit and trial.
And as you bring this up, obviously when someone's talking about personal injury, there's a good reason that it often becomes the butt of jokes about lawyers and late night TV, and all of this is, our discussion is about everything that's supposed to be legitimate, not some of the ones that are less than valuable and worthwhile to be discussed. But when someone's talking about a personal injury case, there's court, but there's a lot that can happen between and before you get to court, whether it's mediation and settlement. Do you think about a court case first, or do you really think about, let's see if we can save everyone that long, protracted process and expense?
Okay, so you covered a lot of things there. So the butt of jokes and that type of thing, yeah, a lot of my friends will tell you about attorneys and the jokes that can go along with that, except for when you need the attorney and it's your attorney, then it's not a joke.
Of course, of course.
The way I approach a case when it comes in is we always prepare the case as if it has to go to court, as if it will end up in trial, so that we're prepared to go ahead and do that if it becomes necessary. The goal isn't, however, to take every case to trial and get a jury verdict on every case. The goal is to resolve the case for what the case is worth and to be fair to the clients, to make sure that they're fully compensated for their injuries. So the insurance company needs to know that you, as the attorney, are prepared to file suit, to take the case all the way through the litigation process to a jury if it has to go there. But at the same time, it helps that if you do this with the insurance companies like we do enough, and they know you'll do that, that you can find some other way to resolve it quicker and without as much expense as bringing the case to court or to a jury in the end.
So I understand in just about all of these things that become personal injury cases, that time is of the essence. What's reasonable? I mean, there are a variety of cases, as you started to cite. If it's an automobile accident, obviously someone needs to get to the hospital first rather than calling the lawyer first, depending on what's going on. But what kind of time frame is reasonable when it comes to the necessity of reaching out to a lawyer?
Well, the sooner the better, because a lot of times there's maybe some evidence that needs to be gathered as quickly as possible. If it's an auto accident, usually there's a police investigation, there's a police report. A lot of times those police reports aren't 100% accurate, and some things need to be addressed in those things, and the quicker you do that, the better off you usually are. Sometimes witnesses need to be tracked down depending on the type of case, and usually the quicker you do that, the more likely you're able to find them and get an accurate statement from them, because people's memories, fade over time, and you need to get something as quickly as you can. Some examples of that in cases I've had, I have a case that we knew that we would love to have settled it, but that we needed to be prepared to take it to court and to trial if necessary. So this was an accident, without getting into the specifics so we don't breach anyone's confidentiality, but a vehicle comes out of a side street, which perhaps was a state vehicle of some type, and cuts my client off, who's on the main road and is on a motorcycle and has to lay the motorcycle down. He's injured as a result of the other person's negligence, who just took off. There was a witness who saw exactly what the vehicle was able to identify it, let the police know that he saw all that. So we were able to track him down and get his information and a statement from him and his contact information, so that when the state fails to settle the case, which they have, and we put it in suit, we'll have him available to testify as needed. And so by tracking him down, his memory is now in his own handwriting committed, so that he can look back at it if he's forgotten 2 or 3 years from now, when the case is reached for trial, to have a recollection refreshed by what he saw and what happened.
As you say, memories can fade or just become altered and less accurate over a period of time. How do you waltz someone through what's going to happen with the case so that you are prepared? Obviously, they may be the source of a good deal of information initially, but then there are other things that you must do that they cannot. How do you work with a client so that you get from them what they need? What do we need to tell our viewers so that they know what they need to bring to you or to think about and have ready for you if they can?
So, of course, there's a couple of things, depending on what type of negligence is involved. If it's an accident, the police report, any witnesses they know of, anything that happened at the scene, to jot it down so they remember. The medical treatment following it, if you've already been to a doctor or a hospital or whatever, and what they've said and prescribed and done for you. So all of the information relevant to how the accident happened and what you've done following the accident. I often recommend to my clients that they might jot down some things about how the accidents affected them day to day. So not a diary necessarily, but something that's important, so they know when it happened, what happened, and that type of thing, so that they might be able to look back at it at some point in time. So what we tell people to do is, first and foremost, take care of themselves. So if you're injured in an accident, make sure you get treated for that as quickly as possible so that you can start on a path to recovery. When you're able to contact the attorney, give us a call. We'll make arrangements to see you to make sure that we get all the information that we can at that point and start getting the case put into a position where we can maximize your recovery when that time comes. A lot of times people will ask, well, how much is my case worth, or when can I expect it to settle? And what we always tell them, it really is a case that we would never settle until we know that you've either A, reached an end result from your injury, or B, if we don't think it's going to get better, you've reached medical maximum improvement.
Plateau of some sort.
And that we can get medical documentation as to what your condition is and what it's likely to be. It's called a permanency rating, and it's at that point in time we would try to settle it. But if you try to settle too soon, then if something comes up down the road that's related to the accident, but you've already settled, you're never going to recover for that. So wait until we know exactly what your medical condition is and what your prognosis is, and never at the beginning of the case can I really tell someone what the case is worth because I don't know what their treatment's going to consist of and how they're going to go and recover medically.
Okay, and so while I was asking you, what do you tell your clients that they should do, there's also, from what I've read, something that's important that you should tell them not to do. Namely, when you mentioned talking to or being with an insurance company, is there some concern, or do you caution clients to not speak to an insurance company because what they say could be used against them?
Right.
Should they really not speak with them? Just say, hold off, I'll talk to my lawyer, or you can talk to my lawyer can talk to you, or how do you handle that, David?
Yes, I would never want my client to give a recorded statement prior to contacting me. I would never want my client to give information really about their medical condition or anything else, or about the accident, because, as you said, the insurance company is going to either record the statement or take things down and perhaps down the road use those things against you. So what I always tell my clients is, if you get contacted by an insurance company, tell them you're represented and that I'm representing you, and have them call me. And insurance companies generally will stop the conversation once you tell them that you're represented by an attorney. They may not, but they should. And when they want to take a statement from my client, if it's my own insurance company, my client's insurance company, we will cooperate because you have an obligation to cooperate with your insurance company, but I want to be there and I want to be listening to the questions and the answers and make sure that there's no misunderstandings or room for misinterpretation of anything that's said. So it is important that right from the beginning, the insurance company knows that there's an attorney and that they should be going through the attorney for any information.
David, would the insurance company be required to say, we're recording this, or could they just have a conversation and, unbeknownst to the client or the injured, not let them know and then use it later? Is that possible?
Generally, they're supposed to tell you that
Okay.
it's being recorded, and especially if they do want to use it later. Although it's legal to record one side to know about a conversation in Rhode Island. In some states, both parties have to be aware of it. But in either event, if you want to use that down the road, there's usually certain protocol that goes into it, such as recording the statement. You understand I'm recording it, I have your permission to record it. You sometimes say, this is being given under oath. If it's under oath, it's not usually. But the proper protocol is to let the person who's being recorded know if you want to use it later.
Good to know. And while you were I was asking you what you tell your clients or ask them to prepare, for all of the names that we say that the lawyers are called that are unflattering, I just heard you being a counselor, certainly, and somewhat of an advocate. You have several different roles. Why don't you explain some of them and how you are working with clients?
So in a personal injury case, we are a counselor in the sense that a lot of times someone has issues that they want to talk to us about that we need to help them through, which could be job related, medical related, treatment related. And oftentimes, having been in this practice for so long, I know some of the doctors and who are good and who may not be quite as good, and I can help get my clients to get the proper treatment that they might need. I've helped people with very severe injuries and helped navigate them through both this medical system in terms of treatment and getting to the right facilities and to the right doctors for the right care, and the medical insurance issues that can go along with that, where sometimes you want to go out of network, as they might say, for medical health insurance purposes, and there's reasons for that, and we've helped clients through all of those types of situations, as well as advocating for them with the insurance companies, advocating with them for both, when I say insurance companies, the automobile liability insurance or the doctor's insurance or for the malpractice cases, or the landowners in a slip and fall case like insurance, as well as the health insurance and all of the other types of things that can come into that. And then, of course, as the lawyer's role of trying to put their case into place to maximize their recovery.
Which means investigation, and it's not just you, but perhaps others who might have to be involved as well.
Sure. The investigation can be done with other attorneys in the office, the paralegals in the office. A lot of times there's investigators who are actually hired in cases to go out and look at things for you. So there's a myriad of people who help the attorney make sure that your case gets to the best place it can go.
So you mentioned earlier that many of these personal injury cases are done on a contingency basis. And then there's, as I've heard, there's retainers and fees, and then sometimes it's just a flat rate. But if you have investigators or people who you have to pay, how does that work? That you would be absorbing that and hope that there's you'll have compensation when there's some sort of settlement later?
For most of those types of cases that my firm handles, we would put up the money. But our retainer agreement does say that when we're successful and we get a recovery for you, we'll be reimbursed from the settlement for the expenses that we front, so to speak.
So what happens if you don't win the case and you've still had those expenses? Would the person who's been injured be liable to at least cover your expenses?
In most cases, our agreement says that we will be responsible for those expenses and would not come back after you. If there's a difficult case and there are some circumstances where it might be a case where we don't think that it's 100% negligence on the part of the defendant and the client still wants us to investigate it, then we might talk to them about either fronting some expenses or being responsible for those. But most cases that we accept will usually be responsible for the cost if there's not a successful outcome.
And what kinds of things are actually part of what personal injury? So I might be out of work and someone might have to compensate that. How do you figure or anticipate what I might also lose in terms of future wages and salary, or what happens to my child care, my marriage, my everything else that affects my life? Is there a formula? Do you have to sit with several other people to determine that? Do you have to do financials with people while they're in the neck in a brace or whatever?
So you're sort of asking what issues go into the evaluation of the value of a case for the damages. So it's a little bit about your economic, non-economic damages, or special damages and general damages, as we might call them, which are special damages, economic damages, out-of-pocket money. So it's medical expenses, lost wages, other lost income that you might have, lost opportunity perhaps. Sometimes I've had cases where someone doesn't have lost wages. They had, for example, a job that they hadn't started yet, but they had an earned capacity that is can be compensated for. So you have to look at what are the out-of-pocket or special damages. So like I said, what are the medical bills, usually lost wages, those types of things. Then the other damages, the general damages, pain and suffering. That's usually the biggest area that can go into the evaluation of a claim for an automobile accident. But there could be other issues that you're talking about. Are you entitled to get compensation when you have to have someone come in and help do certain things? It depends on the situation and what they're doing. Certainly, if someone's coming in to provide some medical assistance, you can get compensation for that. If someone's coming in to do the house cleaning, that's more of a question. And go ahead.
And one that was rather interesting that came up in several of the cases that I was looking at, lack of consortium.
Loss of consortium.
Loss of.
Okay, so that's where I was actually going to go next. So loss of consortium, companionship, it's a husband or wife's claim for their loss of society and companionship with their spouse who's been injured as a result of someone else's negligence. The Supreme Court in Rhode Island has called that a derivative claim. It derives from the person's injury, and as a result, if you can't have a sexual relationship with your spouse or companionship that you normally have to do, or have to do things for that spouse that a spouse shouldn't have to do. And I'm thinking in particular of a client who suffered from a very severe injury. Now her husband has to change her diaper and do things of that nature.
A different kind of caregiving.
Exactly. There can be compensation for that loss. A child's loss of a parent, there can be compensation for, and a parent's loss of a child in certain circumstances.
And is there also another issue about if you assume that somewhere, or not assume, but consider that in the reason that this accident or whatever happened was not just negligence, but perhaps malicious or intentional, is that equal to more money? More of a case?
It depends on the type of case.
Medical?
Yeah, like a medical malpractice case where there's a mistake and,
honest mistake.
an honest mistake.
If it's an honest mistake.
But it's a mistake that a good doctor of standard practice wouldn't have made, so it's a deviation from the standard of care, so it still arises to a medical malpractice claim. That's going to get an evaluation based on the injury. When there's cover-up and subterfuge and,
Yes.
and those types of things, I think a jury generally will look at that and be a little bit harsher against the doctor in awarding damages. So I think the same thing could be said through any type of personal injury case where the defendant or the defendant through his or her insurance company do the same type of thing, and that can be exposed to a jury. So is it part of how you measure damages? Not necessarily, but can it have an effect on how a jury evaluates a claim? Sure it can.
When you anticipate that there might be something like subterfuge or whatever kind of cover-up, is that the kind of case that's more than likely not to settle, or is that equally likely to settle versus going to a full court?
I suppose it depends on the attorneys.
Okay.
If I were representing a defendant and I thought there were real big problems that the jury would see, I might be more likely to want to try to settle that than less likely. But I guess it depends where it's coming from and how it came up and that type of thing.
Do you find that there are big differences, say, between Rhode Island and Massachusetts when it comes to any of the personal injury cases and how they're handled, how they're settled, if they're mediated, or they all seem to run the gamut equally? Or does the law, or does one state favor going to court versus settlement?
So
Is
there
that a lawyer
are
issue?
big differences between a lot of the process of how a claim is evaluated, when you can have a claim. Massachusetts has some no-fault legislation where there has to be a certain amount of medical bills before you can recover for personal injury in an automobile case. So substantive law, there's a lot of differences. The bottom line on the procedure in terms of will most cases settle before reaching a jury or not, it's probably similar. They're done differently, but it's similar in that Rhode Island has court-annexed arbitration required before a case goes to trial, so there's an opportunity for alternative dispute resolution prior to a trial. Massachusetts has other processes similar to that where cases can be arbitrated or mediated before trial. Most attorneys will usually take the opportunity to put a case through once or twice, either an arbitration and or a mediation. So many more cases settled today prior to reaching a jury verdict than when I first started.
Good to know. We say that we want to provide some resources. Findlaw.com, nolo.com, are those worthwhile for people to at least reference before they go too far? Not that, again, that they can represent themselves, but those are reasonable resources, or dmv.org?
They will give you some background information that can be helpful. I wouldn't use any online site to find a lawyer. I would talk to people I know. Word of mouth is usually the best way to find a good lawyer.
Good to know. Thank you. We hope that this has been helpful to you if you should have a personal injury case. Obviously, we would hope that that should not happen to you. Stay tuned to The Law Matters. We will discuss many more issues. Stay tuned to The Law Matters because the law matters to you.